Good morning. This is Neil Rambana with Elizabeth Ritchie. We're with Rambana and Ritchie, immigration attorneys. And today is March 24th. And today we're going to be talking to you. Oh, and this is Byron, by the way. We're going to be talking to you about special immigrant juvenile applications and also VAWA, which is the Violence Against Women Act, and the battered spouse application, which applies to both men and women. To begin, let me tell you that the Special Immigrant Juvenile application is a great application for those minors who've entered the United States and don't have parents that are able to care for them. Their parents have either abandoned them or they're deceased, and they have someone in the United States that they can be a dependent of. If they're designated as a dependent of the state in which they are, because they're going to school and they're able to show that they are under 18 at the time of the application, they're allowed to apply for this special benefit that will eventually give them their permanent residency. So it's a two-step process that we want to ensure that those that are qualified or potentially qualified know about. And that entails, one, they have to file that application for special immigrant juvenile before they're 21. It sounds strange, but 21 is the age for the application, but they must have a dependency order before they turn the age of 18. So that's also important. And that is where we, at our office, we'd like to use the services of an attorney, a family law attorney that will be able to ensure that the dependency order communicates the special, specific language that immigration would want to see in order for them to be able to qualify for this benefit.
Sure. So that is a key age, that 18. A lot of times we see somebody who's already turned 18. That's not going to work. It has to be the order received before the 18th birthday. And that, again, as Neil said, is something you would do with a family law attorney first. Can you talk a little bit about VAWA? You mentioned that it doesn't apply to women only. VAWA stands for the Violence Against Women Act. So people would think just by the name that it's for women.
Right. So that was legislation, which is now law, that went into effect that basically says that if you are being held hostage in your immigration proceedings because you are the victim of domestic violence, and it doesn't necessarily have to be physical violence. It could be mental violence because somebody is holding you hostage and saying, I'm not going to complete your immigration paperwork unless you do certain things. And when that happens, you are allowed to self-petition for the benefit, and you get the opportunity to ask the immigration services themselves, USCIS, for the benefit. And if they were to say that we don't see that you rise to that level, it's okay. You get a second bite at the apple. You actually get the opportunity to ask the immigration court to look at the information that you're providing, the evidence that you have to substantiate why you should receive that benefit. And that also leads to your permanent residency, your green card.
Mm-hmm. So along those same lines as VAWA, which again is for people who are victims of domestic violence, and it can also be violence in the sense of something mental. It doesn't have to be physical violence, just manipulation, psychological manipulation. And that's generally by the spouse, a permanent resident or a U.S. citizen spouse. But what if somebody is a victim of a crime and they're not married to the perpetrator?
So if they're the victims of a crime, then they may be able to file what is called a U visa. If they can show that they have filed a police report, that even if the case is closed, that they cooperated with law enforcement, then law enforcement will certify on a supplement B, a 918 supplement B, which is the application that is essential to get the process going. If they have prima facie eligibility for the U visa, then they'll be able to be in the system for purposes of getting an approval eventually, which will also lead to the green card after 3 years.
So because the U takes about a year or even more right now, that is not part of that 3 years. So the U visa application is pending. If it is approved, then you have 3 years to wait before you can file for your green card, your lawful permanent residency as a U, as a victim of a crime. And they're not just crimes of violence, by the way. You can go on uscis.gov, click on forms, and then under forms, you'll go to the I-918, and then it's the supplement B that he's talking about on the top of page 2. It lists all the crimes that apply, which again are not all crimes of violence. There's, for example, perjury and obstruction of justice. There are labor violations. So that's an alternative, and it doesn't even require that you have entered the U.S. legally.
Now, as a side note, there is also a visa called an S visa. So if you're not the victim of a crime, but you are helping law enforcement with cooperating to be a key witness in that crime, then you can have, and we as the immigration attorneys wouldn't prepare that for you, but you could have the state attorney or the police department file what is called an S visa because of your cooperation.
So there's lots of options for people who may have entered undocumented or became overstays, and these are two good options. Moving away from the criminal realm, I wanted to talk briefly about a couple of new announcements, one of which I'm going to read. It came out late last night, and it has to do with the immigration court. So the EOIR, the Executive Office of Immigration Review, as of last night announced it has postponed all non-detained hearings until April 10th. EOIR has postponed all non-detained hearings. They've also announced that the following courts are closed. These are immigration courts: Seattle, Los Angeles, Olive Street, Sacramento, New York, Federal Plaza, New York, Broadway, Newark, Memphis, Louisville, Houston, South Gessner Road, Charlotte, Atlanta on Peach Street. Those are all immigration courts that are currently closed. The detained hearings, including unaccompanied children in custody, are moving forward at this time. Next, all MPP, master calendar, and merit hearings are presently scheduled through April 22nd will be rescheduled. Any individual with an MPP hearing date through April 22nd should present themselves at their designated CBP port of entry on their previously scheduled hearing date to receive a tear sheet and hearing notice containing the new date. And for updates, you are encouraged to check EOIR's webpage. So that is about court closures. I'm going to move on now to ESTA. I'm getting a lot of questions from people on ESTA. ESTA is basically the visa waiver program. That's for people from certain countries who don't need a visa to come to the U.S., but in exchange for that, they cannot change or extend their visa once they're here. That's creating a problem for people who are approaching their 90th day and cannot leave due to the coronavirus. What should they do? This is a great question, and it seems like no one has the answer. Only Newark and JFK airports have announced how they're handling it. So what about everyone who entered through other airports than Newark or JFK? Well, Jacksonville is our area of jurisdiction where many of our clients reside, and unfortunately we don't have an answer at this time. ESTA holders are receiving that email from CBP that says, thank you for visiting, we hope you enjoyed your stay, it's time to go. And I've been in touch with CBP, and they have instructed us to make an InfoPass appointment. That unfortunately is not great advice at this time. InfoPasses were canceled way before this virus outbreak. So I don't have an answer. I am working on that, and I hope to have news as early as tomorrow. I've sent several emails and made some calls to CBP about how we're going to handle the discretionary 30-day extension for ESTA holders. Hold tight, we don't have an answer yet unless you came in through JFK or Newark. If you did, then you would contact deferred inspections with CBP with those airports, and they should be able to direct you about how you can get that discretionary 30-day extension. Then the next question will be, if this virus situation is not under control in 30 days, then what do those ESTA holders do? And we don't have those answers yet. Please email us your questions. I'm Elizabeth@rambana.com. You can also send us messages through Facebook or comment below, and we will gladly answer your questions. If you have some topics you'd like us to address, again, let us know. We hope that you're safe and that you are following precautions, because that's what it's going to take to get back to our new normal. Thank you.
Thank you.